Start. Para. The only conclusion recorded by the enquiry officer is that since the petitioner did not cooperate with the disciplinary proceedings and that from his conduct it is clear that he does not want the proceeding to be concluded, he had no option but to record a finding that the charges stand proved. It is right law that even if disciplinary proceedings are continued and culminate ultimately ex parte, the inquiry officer is under a positive obligation to record his satisfaction with respect to the charges leveled against the delinquent employee with reference to the evidence based upon which the employer seeks to take action against the employee. Even this rudimentary and settled principle was not borne in mind by the enquiry officer. The mistake committed by the enquiry officer, as noted above, was reiterated by the disciplinary authority inasmuch as neither in the order dated 24 April 1998 nor in the order dated 13th August 1999 has the disciplinary authority recorded any independent satisfaction with respect to the guilt of the petitioner based upon the evidence or material on record. This, of course, subject to the caveat that the failure of the enquiry officer to record his conscience on each charge is not a flaw which could perhaps have been cured by the disciplinary authority for the first time. Para. That leaves this court to deal with the last submission of Sri Mishra, that the judgment and order of this court dated 2 November 1995 conferred authority upon the corporation to continue and conclude the inquiry despite the superannuation of the petitioner. It becomes pertinent to point out here that the judgment and order of the court dated 2 November 1995 required the corporation to conclude the proceeding within a period of 8 weeks therefrom. Admittedly, this period of 8 weeks had expired long before the passing of the orders impugned. This court has not been referred to any material or circumstance which may have considered or injunctured the corporation from proceeding ex parte and concluding the inquiry in case it was its contention that the petitioner was deliberately not permitting the conclusion of the inquiry and adopting a procedure of non-cooperation. From the facts notices herein above, it appears that the corporation fell into deep slumber post 13 April 1996 till it issued a notice on 3 February 1999. Even otherwise, this court finds itself unable to view or read the order dated 2 November 1995 as conferring or clothing the corporation with jurisdiction to continue with a departmental inquiry against a delinquent employee post his retirement in the absence of any statutory provision, rules or regulation conferring such authority upon the corporation. The last significant issue which must be noted is this. Admittedly, the show cause notice was dated 22 April 1999. This notice required the petitioner to submit a reply within 15 days. Even before the said period could expire, the impugned order came to be passed on 24 April 1998. Para. It is where its contention that the petitioner was not cooperating, it could have proceeded and concluded the inquiry ex parte. The report of the inquiry officer suffers from fundamental flaws noted above. These fundamental flaws were not and even otherwise could not have been cured by the disciplinary authority. The clearly establishes a failure on the part of the corporation to follow due process and to act in a fair and reasonable manner the entire proceedings culminating in the passing of the impugned orders, apart from being in violation of the rudimentary and fundamental principles of fair play, and even otherwise rendered without authority of law in light of the proceedings having been continued and penalties inflicted after the retirement of the petitioner on 31 January 1998. Accordingly, and for the reasons noted above, this writ petition stands allowed. The impugned orders dated 24 April 1998 and 13 August 1999 are hereby quashed. The petitioner shall, as a result thereof, be entitled to all consequential benefits and reliefs. Stop.